Let's turn that music down. Because we have our own music intro and, because it's not 10 minutes long, I don't play it. I probably should. You know what? I need to do that. I need to add it to our, I need to add it to my sample board to make our intro music something that
is 10 minutes long.
No. That I can actually, I could just play it, to like showcase the start of it. And then I know what I'm saying in my brain. I know what I'm saying in my mind. I know what I'm saying in my mind. So there we go. Now I have my post-it to myself to remind myself to do the things I need to do. And found a post-it to remind myself to do something to prepare for Saturday, and posted it where I could see it because I completely forgot to work on that today. This is why I have so many post-its on my desk. Anyway, would you like to start a podcast?
I would like to, yes.
And welcome to Learning the Law, a podcast about all things legal with a focus on current events where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy, and my co-host, who is the man of the hour, my husband, Ron. This podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship. This podcast is based on his interpretation of relevant law. Any opinion expressed are the opinions of the individual making them, mostly me, because I'm very opinionated, and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California. I actually should caveat that because I am my business. So my opinions do kind of reflect my business opinions. Like my business opinion would be because as a freelancer, right? So
yeah,
technically that's not fully correct, but we say it more for him, not for me.
That is true.
I also don't claim to be a lawyer. So,
You're just trying to distract me from saying since September 15th, 1999.
Oh my God, every time. Dude, I should just write it into the intro at this point. Also, my hair is like super floofy today. It's driving me crazy. I don't like it. I didn't put any, I need a haircut, like so bad. Speaking of haircuts, someone decided to shave his beard this week and kept the mustache, and I hate it. This is the real reason why he's in the bedroom. No, I'm just kidding. We're coming at you from the bedroom and the office again. We did get some good news. Ron does not have an infection in his foot anymore, per the MRI. It's a broken ankle instead. So now we have to go through the process of getting the insurance to okay the treatment at the university, because the university that he was referred to can actually help. Yeah.
In a nutshell, the infection weakened the bone to where just walking caused fractures in the bones in my foot and ankle. And the surgeon cannot fix it. That's why I have to go to the University Medical Center. So, just a little detail there.
Yay, American politics. I mean, American health. It's also American politics because America. Okay, awkward segue. We're going to talk about Jim Crow laws tonight, but We're going to start off talking about the Dirk Chauvin case and highlight what they talked about in the last 2 days. And we are going to try to do a TikTok every day giving highlights and on what happened. So I have something in my eyeballs. So I'm going to do my best to read this. But yeah, I asked Ron right before the podcast. I was like, I think it'd be kind of cool to do a daily update on this, or at least every other day for the case, because it's going to last at least 4 weeks. It might last more. Could it be less than 4 weeks? Because I know when my mom was sequestered on a trial, it was a massive murder case. It was a big murder case. And like, she couldn't talk to us. Like, it was pretty crazy. And she was supposed to be gone for 2 weeks or 3 weeks. And it only was like a week and a half. So, in a case like this, do you think that it could be less?
Trial lengths are always estimates.
Okay. So it's not guaranteed it's going to be.
Usually what happens is you estimate more than you really think it's going to take place. Okay. Because if you estimate short and you have another trial that's coming up, all of a sudden you create backlogs and clogs, and everybody was ready to go, and witnesses have to be told when they're coming, and it just creates a logistical nightmare.
Okay. So it shouldn't. So the answer to that then is yes, it could end sooner than 4 weeks, but no.
Probably not.
No, but no on it going past 4 weeks.
If it goes past 4 weeks, while it's not likely, because the lawyers and the judges know what the evidence is and how long it should take to present it. If for some reason it goes past 4 weeks, it's because there's either additional evidence that's coming or a line of questioning that wasn't thought of at the beginning of trial.
Oh, okay. How often does that happen?
Rare.
Really? Okay.
Yeah. Yeah. By the time you come to trial, everybody knows who the witnesses are. There's no surprise witnesses. There's no surprise discovery of documents that you see in the movies all the time. If a witness is not disclosed before trial, 99 times out of 100, they don't get to testify.
So I'm gonna be real honest here. I'm very opinionated. If y'all haven't gathered in 11 episodes, I'm extremely opinionated. He's the one who tends to be a way more cool and calm and collected and just the facts, ma'am, because he's the attorney.
It is a law podcast.
Yes, and it is a law podcast. So I'm going to do my best, at least for this specific podcast. I'm always going to put my opinion in it because it's my podcast and this is how I want to do this. But for this particular cast, I'm going to do my best, at least with the Chauvin case and the Chauvin information. I'm going to do my best to not be too opinionated and not run my mouth too much with that, because I like to talk and I like to hear myself talk and I want people to be better. And so I guess somehow in my mind, if the more I talk and the more you listen to me, like the more I don't know. It's freaking trauma brain. Okay. It's trauma brain. All right. I'm convincing myself just as much as I'm trying to convince others. However, that being said, we're just going to start right off, even though we're not really diving right in like we did last week. Man, I fail at this podcasting thing sometimes. charges for the Dirk Chauvin case. Oh, so he's being charged with second degree unintentional murder, third degree, and second degree manslaughter. Can you please explain what all of those mean?
Okay. And this is according to Minnesota law.
Right, because he's not being tried at a federal level.
In Minnesota, second degree murder can be either intentional or unintentional. And I'm not going into my opinion of what happened in this case as to whether or not. But according to Minnesota law, what they have to prove for this second degree unintentional murder is that Mr. Floyd's death was caused without intent to affect the death of any person while committing or attempting to commit a felony offense.
Okay. Can you explain that in like real people terms?
Yeah. So what it means is that you killed somebody but didn't intend to kill them while you were committing a felony. In this case, assault on Mr. Floyd.
Okay. So, okay. So now why is he not being tried for second degree intentional murder?
Well, one, it's the same sentence, up to 40 years. Although Minnesota guidelines recommend 10 to 15 years. I am speculating that the reason that they didn't go for just second degree murder intentional is because intent when it comes to police has been notoriously difficult to get a jury to convict on.
Okay.
Historically.
Okay.
So since they can go with the unintentional, not having to prove the intent, and you still get the same sentence out of it, is a lot easier burden for the prosecution to prove.
Okay. That actually makes sense. So when it comes to and you could also argue that when he before he showed up, he was not going there to intentionally kill someone. He was just going to deal with a situation that was called on or whatever.
Correct.
So the intent wasn't there, I guess, until he got there. So third degree murder it's third degree murder.
Yeah, third degree murder is the second charge.
Okay.
And in Minnesota, third degree murder can also be thought of as a depraved mind. And it's without intent. You cause the death of any person by perpetrating an act dangerous to others without regard to human life.
So is it kind of like like he just kind of went crazy in the moment and was like, I'm just going to do it? Or
not necessarily crazy, but you just consciously disregard the effects of what you're doing.
Okay. So he's not getting away with murder necessarily. It's just he was not in his right. I still feel like that says he's not in his right mind.
It's a sentence of 25 years. And that is the charge that the police officer in Minnesota, Mohammed Noor, was convicted of in the death of Justine Damon in 2019.
Okay.
It is much easier to prove that crime than the second degree. In such that kneeling on somebody's neck without regard for his life, in 9 minutes, you're going to kill him.
So,
but at that point, he didn't care.
So the second degree manslaughter.
Yeah.
Also, can you explain the degrees? Like, so second degree is worse than third degree?
Second degree is worse than third degree. It's the exact opposite of like burns. Third degree burns are the worst. That's not true in crime. First degree is the worst.
Okay.
And that's usually premeditated murder. You plan it out, you lie in wait.
Okay,
that kind of thing.
So
second degree manslaughter. All they need to do is that Officer Chauvin was negligent when he created an unreasonable risk and consciously took chance of causing death.
So kneeling on him for 9 seconds, cutting off the wind, his windpipe.
9 minutes.
Or 9 minute, I'm sorry.
Yeah.
So
trained or not in what to do, a reasonable person knows. You just know kneeling on someone's neck with your full weight for 9 minutes is going to kill them. And second degree manslaughter is a max 10-year sentence.
So when it comes to murder versus manslaughter, can you explain, because they're both killing someone, can you explain the semantics there?
Generally, the difference is the degree of either negligence in your actions, whereas one is like, oops, I'm sorry, this was an accident. I really
manslaughter?
Didn't mean it.
Would
that's
manslaughter be like, oh, my bad, I killed you?
Right. That's manslaughter is like you get into a bar fight and you hit the guy in the head. He's hitting you, you hit him in the head, but you crack his skull.
Oh, or like a car accident. And where the other
accident is called vehicular manslaughter. Yeah.
Okay. And then murder is when you know what you're doing.
Right.
Interesting. So even though these sound like they're not, because I mean, it sounds like they're like with the first two, it sounds like they're trying to justify, or not justify, but like explain his mindset. Like, how white people always get the whole, oh, he was insane, like the mental health hook, right? But in reality, they're not necessarily going for that reason. They're going for that because they think that's what they're going to win with. It's a matter of that.
Right. And I will take an example from the OJ trial. In the OJ trial, they just went with one charge. They went with the murder charge. No lesser charges like manslaughter. And so they rolled the dice on all that. Found him not guilty. In this case, the prosecution is hedging their bet that if they can't get the jury to convict a ex-police officer of murder, that they can at least get him on the lesser murder or the manslaughter charge.
Gotcha. So in chat, Rough Galaxy says, second would be the equivalent of allowing an untrained mechanic work on someone's brakes if it resulted in death, or losing control of a vehicle would be called involuntary manslaughter.
If it's a vehicle and you lost control, it's generally, depending on your state, still vehicular manslaughter.
So
but
it
would be involuntary.
It's in its own category. essentially. Right. Okay.
The bar fight, where you hit somebody in the head, that would be involuntary manslaughter.
Oh, okay. Okay, good question. Thank you for the question, Ruff.
Because you don't anticipate killing somebody from a punch.
Right.
Now, if you took the pool cue from the pool table at the bar and hit him over the head with it, that is arguably voluntary because you can crack his skull with a pool cue.
Interesting. So, in your opinion, should I wait to ask you this? And should I wait to ask you your opinion on whether or not you think these are viable charges after we talk about the first 2 days? Or
no, I think they're viable charges, in my opinion.
You do? Okay. Is there anything you would have added to it or tried to add to it?
You really can't prove first degree. So there's no point in trying to bring a first degree charge. But
you wouldn't stack like assault and you wouldn't try to stack like as many as possible, like assault and battery and...
I don't think I would, because, and this is just me in my opinion, if I was a prosecutor, I don't want to give the jury a chance to give them such a less charge when somebody died that they're only going to get probation and a fine.
Right, but wouldn't that be better than them getting off completely? Or would that just be a matter of you just didn't do your job well?
Well, here's my other opinion. Defense attorneys do not win cases. Prosecutors lose them.
That's a bold statement, Cotton. Let's see if it pays off.
Yeah.
What? Okay.
Prosecutors have to do their job. And if they do their job and, if they don't have the evidence, they shouldn't have brought the charges.
Was OJ guilty?
In my opinion. Because I watched that entire trial.
Yeah, I know. Are you willing to put your opinion out there? Or do you want to just kind of...
DNA does not change to somebody else. OJ was guilty.
Okay.
My opinion of the legal evidence. I know it's not a popular opinion.
But based off, because you watched that entire... Because you have told me multiple times that you've watched every day, very much like this case. This case is very much like that. And the judge actually okayed this trial to be broadcast with, caveats and like, they're not showing the jury because they have to be sequestered and everything. Even they had children testifying today and he didn't want to use their names. Now, a lot of like NPR and PBS and a lot of the news outlets have given their names out because they have the right to do that. But the judge did not even live stream their testimonies. He didn't want to because they're children. He didn't want to put that on children, which I really respect that from this judge. I really, really respect that. I also want to note before we get into the trials is everybody's been giving this judge flack for not wanting to move the case. And in doing this research and looking it up, I understand and I get why he wouldn't and why he said we're just going to do it here, because he's right. Anywhere else, and because of the size and the weight and the exposure of this case already for the past year, it's not going to be any different anywhere else in the state of Minnesota. It's not going to be
correct.
It's not going to be different. So there is no point in moving the case. There's literally no point in moving the case right now. So I understand his decision on that.
You can't get a fair trial here due to the publicity. You're not going to be able to get a fair trial anywhere in Minnesota.
Right. Exactly. And I also think it's interesting that and this is the first public trial. This is the first trial that's ever been live streamed or public to this degree in Minnesota. And I don't know. What are your opinions on the judge? Because like a lot of people were giving him flack for it, but in looking at it, I don't think he's one way or the other. I don't think he's shown any decision one way or the other. I think he's trying to be a judge and do his job.
So far, I don't have any problems with the judge. I think he recognized the fact that this is such a big trial that it needed cameras.
Yeah.
Because any time you have a hearing that has limited audience, which the courtroom can only have so many people, you're going to have public opinion every day saying something's being hidden, something's being covered up. So I don't think he really had a choice but to live stream it.
And I think that says a lot about where his mind is on this case. Like he knows that it's a historic case, and he knows that about people, and he knows that essentially the trial has happened publicly. So let's actually show the legal system at work publicly, because I mean, it's happened publicly. The trial for this man has happened publicly, and I will flat out say he deserves to go to jail because he killed a man. However,
I will reserve judgment until all the evidence is in.
Yeah. I also have made this decision based off of the little bit of evidence I have seen and heard.
We have seen all the prosecutor's evidence. So far, we have not seen any defense evidence.
Yeah. So the first day, you want to jump?
I have one other thing about live streaming.
My bad.
You'll also be able to see who plays to the camera and who plays to the jury.
I will. Okay.
There will be attorneys who are in a videoed court, and you will see them try and sway the public opinion, not necessarily the jury. And you'll have to watch the defense counsel and the prosecutors in this case to see who they are actually trying to persuade.
I think that's a fair statement. And their job is to keep it in the courtroom and talk to the jury. So that'll be interesting to watch. That is a very valid, interesting statement. So moving on into trial day one, the prosecutor is Special Assistant Attorney General Jerry Blackwell, and the defense attorney is Eric Nelson. I don't know what firm Nelson is with. It didn't say. I'm sure I could look it up. It wouldn't be hard to look up. I didn't care enough to look up which firm he works for. But I am curious. So what does it mean when they say prone restraint is a central factor in? So in the opening statements, one of the things that was said was prone restraint is central factor in opening statements. Is that just the article just saying this is where the opening statements focused around?
Right.
Oh, okay. All right. When I first read it, it was weird. And now that I'm reading it a second time, I'm like, oh, never mind. I get it. But I put it in my notes. So whatever. So the arguments from the prosecutor is, well, one thing he said was it was indisputably an excessive use of force, that we have known about the dangers of, and I am just picking out pieces of things that he has said from the NPR article that I read from day one.
Okay.
I will post that. Whoops, that didn't do what I wanted it to do. Trying to copy and paste, and I copied and pasted the wrong thing. There we go. I copied and pasted the NPR article, which is also in the show notes, which will be up on the website tomorrow. So back to it. That we have known about the dangers of the prone positions for over 30 years. Floyd's body was making involuntary movements while being held, including a seizure and agonal breathing from oxygen deprivation. And that Chauvin doesn't let up after being told twice that there is no pulse, even when a paramedic sought a pulse. So those are kind of the highlights of his arguments, of his opening statement.
And I'm sure he'll have an expert about the prone position testify. And he'll have a medical expert testify about the involuntary movements, as well as the actual paramedic. Because don't forget.
Can you do a quick for people who don't, for our audience who is not from America and who doesn't understand, can we real quick sidebar? Can you explain what opening statements are? Because I know a lot of people have seen this stuff in the movies and it's kind of sort of the same, but also not. The way the movies do it is not accurate. So, which I know only because he complains about it every single time we watch a movie with a trial in it. So can you explain just the basics of how trials go? Yes. What opening statements are, how they show the case, the evidence, and then closing statements and all of that stuff.
The first phase of the trial is jury selection.
Okay.
Where each side gets to question potential jurors and eliminate ones they don't like or seem to be biased. Once you get your jury selected, the trial, quote, the trial starts. And it starts with opening arguments. In a criminal case, the prosecutor gives the first opening argument, and that's usually where they will tell you the story of how the person, in this case, died and what they're going to show you and how they're going to prove that the charges against the defendant are viable and they're guilty. Now, in rebuttal, the defense attorney also gets an opening argument. Now, they don't have to go immediately. They can wait until the prosecutor has presented his case and then give their opening argument at the beginning of theirs. In this case, the defense attorney elected to go after the prosecutor. And what the defense attorney usually does in their opening argument is tell you why the charges fail to show any kind of guilt on the defendant and why the prosecutor's argument is wrong.
Okay.
After that, the prosecutor gets to present his case. He gets to present all the witnesses. He gets to present the evidence. Now, when he brings up a witness and after he questions a witness, the defense attorney then gets to what's called cross-examine the witness. And then once that is all done, the prosecution rests and the defense attorney gets to bring its evidence and its witnesses. One of the things that most defense attorneys do in these high-profile cases is ask the judge to throw out the charges at the beginning of the presentation of their case, because they will say the prosecution did not show enough evidence to prove any of the charges. That's just a pro forma argument. It never really flies. And then, they get to bring their witnesses. The prosecutor gets to cross-examine the witnesses, and then the defense rests. And then you will have the closing arguments, where the prosecutor goes first, sums up the case, sums up all the evidence that he brought, and tries to show how the defense evidence fails. Then the defense attorney gets to go, and he will do the same thing. He will show how the prosecution's witnesses and evidence fail, and how his evidence and witnesses show that they're not guilty. Then the prosecution gets to go one more time to rebut what the defense said.
So the prosecutor gets to go twice, where the defense gets to go once?
Yes, the prosecutor gets to go twice. The second time, he has a limit to what the defense said. He can't bring in anything new.
Oh, okay.
And
the defense can't rebut that at all?
Yeah, defense can't rebut the prosecutor's rebuttal.
But they can, oh my God, object. Oh my God, I just had a brain fart and couldn't think of the word. They would have to try to object during that questioning to...
You mean during the rebuttal argument?
Yeah.
Yeah.
Okay.
Judges don't like objections during closing arguments. You're usually going to be overruled, and if you do it excessively, you may be reprimanded in front of the jury.
Okay. All right. And then the jury...
And then after that, the judge gives the jury the instructions as to the elements of the crime, and what actually constitutes second-degree involuntary or an intentional murder, third-degree murder. And it's on the long form. There's a bunch of checklists they can go through and check off. This element of the crime is present. This element of the crime is not. You have to have all the elements of the crime present in order for there to be a guilty verdict.
Okay. And then they go away for deliberation.
Yes. However long it takes.
Wow. Interesting. So thank you for that, for explaining that. So we'll continue. So Eric, the defense attorney for Derek Chauvin, Eric Nelson, his arguments are the use of force is not attractive, but it is necessary. It is a necessary component of policing. I'm going to refrain from my opinions on these arguments. He did what he was trained to do. And one of the statements he said was the trial will bring battles over how facts are interpreted, mainly the cause of death, and that the coroner's report found no evidence that Floyd died of asphyxiation and that Floyd put drugs in his mouth in an effort to conceal from police, and blames the crowd for distracting the cops and causing chaos. That was in the opening statements. I'm bringing this to you with no opinion. As much as I want to, I can't tell you how much I really want to make an opinion about all of this, but anyway, we will continue. Speaking of the coroner's report, the autopsy report, the medical examiner ruled that the death was a homicide and the heart and lungs stopped functioning while being restrained. The coroner cited that the neck compression, other significant conditions, including fentanyl intoxication, recent methamphetamine use, and signs of heart disease. So essentially what the autopsy report states is it's everything, all of the above is what ended up killing him. It was, the perfect storm.
Right.
Is what the autopsy report says. It
never uses the term asphyxiation, does it?
No, it does not ever use the term asphyxiation. You can look at they don't really go into NPR didn't really go into detail about the autopsy report, but I'm sure you could look it up to look at the actual report. The Hennepin County medical examiner ruled last June that Floyd's death was a homicide, saying his heart and lungs stopped functioning while being restrained. The autopsy report cited neck compression, but it also noted other significant conditions, including fentanyl intoxication, recent methamphetamine use, and signs of heart disease.
Now, I'm going to say this. A homicide ruling in an autopsy report does not necessarily mean a murder.
Interesting. Okay. Can you elaborate?
Yeah, I'm looking it up right now.
I'm bringing you information that you're not 100% sure on.
I want to be correct.
Okay. That's fair.
It is important to note that the medical term homicide is different than the legal definition of homicide. Homicide in medical terms means the death is caused by either direct or indirect actions of another person or persons. Homicide does not mean murder, manslaughter, or any negligence.
I mean, so if it's a result of a person, you could. Okay.
Right now, it's a fine line distinction, but the coroner does not get to judge that somebody murdered somebody.
So how can they rule it's a homicide if they can prove that someone was the cause of this person's death? Doesn't that say murder?
Oh, I'll give you an example. Someone gets lost in the woods. 2 years later, the body's found. It's kind of decomposed. Can you tell me how that person died?
I can't. I don't have the ability to do that.
Right. That's going to be labeled a homicide.
How?
Because it could have been by a direct or indirect action of another person in the woods.
Oh, so because you don't know exactly how they died.
And I'm putting this in a nutshell, there's other evidence about that. But if you truly do not know how someone died, they will put undetermined on the death certificate.
Oh, okay.
But if there's any kind of evidence that the body found had some kind of trauma to it, it will be labeled a homicide.
Okay, so the body just has to have trauma to it for it to be labeled a homicide.
Right.
Regardless of whether or not that was based off of a murder or anything.
It could have been a slip and fall off the cliff.
Okay, could have been a tree landing on you.
Right. Well, if the tree was chopped down by somebody and they didn't know.
Oh my God.
You know.
Interesting.
Otherwise, yeah.
So, okay. So medically, so basically what you do is you take the medical report and use it to get the legal homicide conviction.
Right. If that
if you think you know who it is that killed them, if you think you know that based off of this, that is so confusing. Oh my God.
Right. If that report said undetermined, the defense then has a report that says, if the coroner doesn't know how this guy died, how can you judge how this guy died?
Right. That's so confusing. Oh my God. That is. Holy cow. That is really. Okay.
And
I don't know what else to say to that. I need a coroner or a medical examiner to.
Yeah, I'm not a medical professional.
Give us a better explanation because I'm still confused on that.
Sorry.
Okay. Let's go to the witnesses. So the first witness that they brought in was a lady named Jenna Scurry. She was the 911 dispatcher. Y'all. Reining it in. She was the dispatcher who sent them to the site when they got the call. And they have like video footage of all of the cams and stuff like that. And she said while she was watching it, the footage of Chauvin happened to be up right in front of her. And she was watching it. And she said she thought it was frozen because he was kneeling on him for so long. She thought because it was the dash cam. So this wasn't the body cam. It was the dash cam that she was watching. So she thought the dash cam feed was frozen. We've all seen dash cam feeds. So you can understand what that, like, they're not the greatest. And so she called, she knew that there was something wrong. It didn't feel right to her. So she called the sergeant that was over those officers on the scene. And she said that she didn't want to be a snitch, but she knew something was wrong. And there's a lot more. They go into a lot more detail about what she said, but we're just highlighting the case and what they're talking about. And so that was her record of the 911 call because it felt weird. It looked weird to her while she was watching it. The next witness was Alicia Oiler, who was a cashier across the street. Wasn't a cashier at the actual. They didn't say she was a cashier at the actual store, but she was across the street. And she happened to have 7 different recordings of the incident. I don't know if they're from like footage of cam footage or phone footage from different people, but she happened to have 7 different recordings of the incident. And when she was asked why, she said because she always sees police and they're always messing with people and it's wrong and it's not right. That was her response. So she made sure that she could record it all, I guess.
Do you know if there was any cross-examination of her?
I'm sure there was. This was just a really, it wasn't, they didn't really go too in depth on her.
Okay, because I would assume the defense attorney is going to cross-examine her and say that she's biased against the cops.
Yeah, they didn't go into detail. I'm reading I like the website. The article is NPR. It wasn't a deep dive. It was just highlights of it. Because we're supposed to be highlighting this, and this is pretty much the entire podcast today. So the final person was Donald Williams, and he actually finished his testimony today at the beginning. So he is a martial arts trained fighter. So he's an MMA fighter, and he had a picture of Chauvin holding with his hands in his pockets, looking at him in the camera, holding down Floyd. And he said that the reason why he had that picture, why he was looking right at him, is because he had just told Chauvin that the chokehold that Chauvin was used is a blood choke. And a blood choke, for those of you who are not aware, I had to look this up too, is a chokehold that cuts off the flow of blood to the brain. And he said that is the chokehold this man was using. And this is a guy who has been doing mixed martial arts for years. He teaches it, and he has been in security for years. And he ended up this morning, he called 911 because he felt that he had witnessed a murder. And so he called the cops on the cops. And the cross-examination, I watched a video, and the Nelson, the footage that I was able to watch, Nelson was asking him about calling Chauvin a bum, screaming curse words and slurs or not screaming, but saying curse words and slurs at him. And he said, you get agitated and get angry throughout the video. And Williams responded with, no, I'm pleading, because he was asking him to get off. And Nelson was asking him, did you call him a bum? Asking him all of these things. He never denied calling these things. And basically, what I witnessed was a white man trying to get a black man to look like a stereotype, and you can see it in the demeanor of this man, the way this man is trying to talk to the witness. And it was awful. I wanted to punch that man in the face. I wanted to throw my computer out the window, because I witnessed this conversation, and I'm just like, to me, it is obvious that this guy wants this guy. It's obvious that this attorney wants to discredit what he's doing, is trying to discredit Williams and make him look like the stereotypical angry black man, so that it discredits his testimony. And that was so obvious to me with what he was doing.
That's one tactic a defense attorney will use.
And I'm irritated at that. Yes, that's an opinion, but that's also factual, because I know it's a tactic that they will use, because he's trying to discredit the witness. After he finished up his testimony today, there were 4 teenagers who testified. 4 children. 4 children. And I have very little evidence. I have very little information on the cross-examination of that, because it wasn't live streamed. So,
right.
Because the judge ruled that, the judge, in my opinion, rightfully ruled to let them, have an anonymity in that. And even though their names can be public based off of news outlets, they also asked if they could refer to the kids by their first name, and the judge said yes. So Darnella, the first one, he wanted them to be kept confident during the trial. So they didn't live stream it. They didn't share their full names. But Darnella, who was 17 at the time, her video is the one that went viral. she had her cousin, Judea, 9 years old, and then Kaylin, 17. And I couldn't find anything on the fourth person. And the things that they say about the things that these children talk about, they watched. Kaylin said she saw Floyd go limp and look kind of purplish. And they witnessed this man's death. And the perspective that they had, like they came up on it after it was happening. So they didn't catch the beginning part of it. And that was one thing that the defense attorney did kind of, what is it? Capitulate? Is that the word I'm looking for? He latched onto. And
capitulate means surrender.
Okay, yes. Then that is not the word I was looking for. I don't know what the word is that I was looking for, but he latched onto that and said, well, your perspective is from behind the car or from the back of the police car. And he's constantly bringing up the chaos and the fact that people are asking him to be removed or asking him to stop kneeling on him. And he's just really, really pushing that narrative. He really seems to be pushing that narrative of the chaos and that it distracted the officers. But there was an officer who wasn't doing anything. It was, I don't know how to say this guy's name. I haven't heard anyone say it, so I'm going to assume it's Tao. I'm sorry if I am mispronouncing his name, but also at the same time, I don't give a crap because he was part of the problem. He was yelling at the people on the sidewalk to get back, and he was dealing with the people on the sidewalk, and he never tried to stop Chauvin, according to the witnesses.
Is this the rookie cop?
I have no idea. I don't know.
I do know there was a rookie cop on scene that it was his third or fourth day.
She said that he was so angry at them and was pushing them, and each one of them said that they were afraid, they were scared for their life because they were all there. And every single one of them talked about being threatened with mace by Chauvin. They were all terrified of him. These are children. And the final witness, which will finish her testimony tomorrow, is Genevieve Hansen, who is an off-duty firefighter EMT. I don't know if she was a firefighter or an EMT. They keep using those terms interchangeably, but they're not interchangeable. They are two distinct positions. They are two distinct jobs. So I don't know if she's a firefighter or an EMT, but she testified that she was not allowed to give CPR to Floyd. And even though she asked to give the CPR and chest compressions to him, and then she was reprimanded by the judge, which this is something that I wanted to talk to you about. She was reprimanded because in the footage that I saw, the judge said, and I'm paraphrasing here, that she's not to argue with counsel. She's not to argue with the court. And she said, well, I was finishing the question. And he said, I will finish. I will say if your question is finished, you don't get to add on to it. And explaining to her how you answer your questions. You just answer the questions. And a lot of people think that a lot of y'all don't really understand the justice system and don't understand that that's not something you want to do. You do not want. Well, I'll let Ron explain that whole situation.
The worst witness you can have on the stand is one that will not shut up. They think that they can out-lawyer a lawyer. They can't. they will go and try and explain and explain and explain. And all you're doing is giving the side that's going to cross-examine you ammunition to make you look stupid.
So if you're ever called
Now,
to testify in a situation, just answer the question as is. Don't add anything onto it.
right now, tonight, Mr. Nelson, defense counsel, is going to go over the transcript of what she's already testified to, word for word. That will be some cross-examination I'd like to see.
So we'll see her stuff, more of hers tomorrow. The only thing that we got was that the only thing of significance, the highlight of it, is that those two things. I don't think they've properly cross-examined her. There wasn't a whole lot about it because it was the end of the day and the podcast was starting up. And so I'm sure the articles and stuff about her testimony, more will come out after the podcast. But we're going to do our best to do a daily TikTok in talking about the Chauvin case. So check out Phoenix Nymphy's TikTok.
Some other things to say about that too.
Yes.
The judge cannot tell the witness how to answer a question. He can tell the witness that they have answered the question. There's a difference.
Yeah, that's what it sounded to me. That he was talking like in the conversation. What it sounded like was she was actually done with her questioning, and then they started to ask another question, and then she, basically tried to argue.
Some judges will allow a witness to talk on for a certain amount of time because they don't want to be seen as heavy-handed, and they will let the attorneys make a motion to strike the testimony. But I'm going to assume this judge wants to rule his courtroom with somewhat an iron hand and not let the child get away from him. So he's setting his boundaries early.
Oh, okay. Interesting. So with that is the first 2 days of the Chauvin trial, and we're at the end of the podcast. So what was supposed to be mostly about the Jim Crow laws ended up being us discussing this trial. So we will do Jim Crow laws next Tuesday.
Yes.
We'll do Jim Crow laws next Tuesday. And we will, if you are interested in our daily update, please go check out TikTok. I think what we'll do is I'm not sure if we're going to do a live stream or not, because I do live stream on Thursdays and Fridays here on Twitch. So we'll see how that goes. But I will definitely watch this trial for you all, and we'll make some content. I want you to stay informed. And this is a historic case. Like, this is a really, really big case, and the country should be watching it. It's huge. The country should be watching this case.
Definitely. I will be watching as much as I can. I do have to work while it's going on.
Is there anything else that you want to say?
No, not at this point. Other than, there is the innocent until proven guilty theory of American jurisprudence. So you're going to have to really wait until the defense presents their evidence. Because if the prosecution does their job, at the end of the prosecution case, they're going to look as guilty as hell.
Right.
And if they don't, the prosecution has not done their job.
So right now, which is why you want to watch the trial in full, because right now what you're seeing is him being guilty. You want, like, that's what they want. They want you to think that he's guilty. That's why you both get a chance to talk. So we have to wait. Thank you for stating that. Yeah, if you think he's guilty right now, well, you're supposed to. Like, that's how you're supposed to think right now.
Right. Also, remember, you have to be found guilty beyond a reasonable doubt. That does not mean all doubt. And we can get into that later.
Okay. I will say that I will put a little dig in that people of color are usually guilty until proven innocent in this country. So,
I'm not saying they're not.
No, I'm just saying that for the listeners. This is my opinion coming out. This is my opinion, but yes, people of color don't get trials. They don't get proper trials, in my opinion.
Do you know what the jury makeup is on this?
Yes. So the jury makeup up on this is, and I quote in PR, more diverse than Minnesota itself. There are two black people it's 3 black people and 2. Don't quote me on this because I don't remember the actual numbers, but there are like 2 or 3 black people and 2 or 3 people who identify as mixed race. 6 women. I remember that number clearly for some reason. And then men, obviously. It's a pretty diverse group of people, which is good.
Your jury's 12 people. There'll be a couple of alternates. So that means there's 6 men, 6 women, 6 black and or mixed race. So I'm assuming the other 6 are white.
I would make that assumption as well. So it's pretty good. I'd say that's a pretty good makeup for a jury.
In Minnesota? Yeah.
It's more diverse than Minnesota itself.
I was expecting it to be 80 to 90% white.
Yeah, because Minnesota is in a very white area. Or it is a very white state. So Minnesota. And with that, we're going to close it out. Thank you so much for listening to Learning the Law. If you like this podcast and want to hear more, don't forget to like, subscribe, follow, and share in all your favorite places. You can find it hosted live on Twitch at twitch.tv/PhoenixNymphy every Tuesday. Please use the hashtag Learning the Law. That's right, hashtag Learning the Law on all social media platforms. I use it on Instagram. I use it on Twitter. I use it on TikTok. I don't do Facebook because no. So yeah, I guess just those 3 social media platforms they're the main ones. Anyway, go check all of that stuff out. And we will be hopefully back tomorrow on TikTok with our assessment of tomorrow's day. Probably do it live just because I'm lazy and don't want to edit the videos. But anyway, that's besides the point.
And Jim Crow, and it's possible come back next week.
Yes, you can find Ron on Twitter at NecroKijo and me on social media platforms at Phoenix Nymphy. If you have any questions, please tweet, comment, or email us at twolazydogsmedia@gmail.com. This has been a Two Lazy Dogs Productions.